Assalamualaikum and a very good day to Sahai and everyone watching this video. Today our firm Nur Ali's YUUN and Associate will present regarding the assignment given to us. This is the name list of our group member who will be presenting in this video. Today we will explain in regard to the provision under Evidence Act 1950, particularly Section 8, which govern the admissibility of motive, preparation and conduct as evidence. As for introduction, the general rule is that motive, preparation and conduct are admissible as evidence. Subsection 1 of the provision explain that any fact that illustrate motive and preparation are relevant if such fact relates closely to the fact in issue. Meanwhile, subsection 2 stated that conduct of any party, his agent, the offender are relevant provided that such conduct has immediate relation to the facts in issue in the case. In the case of Wong Fong Hin against PP, where in this case the appellant had tried to sexual assault or interfered with his own daughter, and this information is known to the mother. The mother told the headman of the village regarding the matter 3 months before the daughter was killed. In this case, there was only circumstantial evidence that show the appellant killed his own daughter. The court highlighted that Section 8 of the Evidence Act 1950 will be material when the case involves circumstantial evidence and not direct evidence. The appellant conviction was affirmed by the court.
Assalamualaikum warahmatullahi wabarakatuh and good day. I am IZZATI. So, the word motive denotes the reason for which people initiate, continue or terminate an action or behavior at certain point. It also known as the driving force behind a particular action. In a case where direct evidence is absent and the prosecution only relies on circumstantial evidence, motive will become one of the most important pieces of evidence to be proven. Motive is provided under Section 8 of the Evidence Act 1950, which can be easier to understand by referring to its illustration A and B. Next, both intention and motive focus on a person's mental state, but intention is about the decision to carry out a specific action, while motive is the fundamental reason for the person to carry out that action. In Padmanabhan anak lelaki Nalianan against public prosecutor and other appeals, court referred to Ratanlal and Dirajalal's book, which stated that motive is the ultimate end which a person hopes to achieve, while intention is the immediate effect of his act. The significance of motive is discussed in Abdul Samid's case, where the court states that motive becomes an important element when the prosecution relies on circumstantial evidence, but it was not an absolute must. If motive is absent, the accused will not automatically be free from the charge. Next, in Manimaran's case, motive is important in case that relies on circumstantial evidence, but the absence is not necessarily fatal to the prosecution case. Its absence actually assists the court to come to a conclusion. Next, the admissibility of motive is discussed in Bhutta Singh's against public prosecutor. The counsel here argued that the police report made by the deceased 9 months before the murder was inadmissible under Section 32 subsection 1 of the Evidence Act. Thorough judge agree because Section 32 subsection 1 is limited to statements made by person at a brink of death. However, court provides that it is admissible under Section 8 because the action of making police report indicates that the accused and deceased were on bad terms. This is supported by Whitley Judge, who states that the action of making report shows that there has been some trouble between the deceased and accused, which then constitute motive. That's all from me. Thank you.
The relevancy of motive. Motive is considered a relevant fact that is admissible, however, without it, it will not weaken the accused's conviction. Thus, Kupaja in Rajendra Kumar and State of Punjab states that in an absence of motive is considered a circumstance relevant in assessing the evidence. In the case of Lincoln and public prosecutor, the accused was in a state of financial embarrassment and this would be a motive for him to get ransom money. The fact that the accused had a close relationship with the complainant in the past but she now has another person can be a motive for revenge regarding their love interest. However, if the motive was not established, the element of conduct and preparation is also applicable. Here, the extortion to threaten the complainant's son life would be the conduct, although the first 2 extortion letters were not written by the accused. There is evidence that indicate that the 3rd extortion letter could be of the accused. To add, the accused's compliance with the procedure that has been outlined in the extortion letter shows the conduct of his crime. As for the preparation, the accused did the extortion letter after knowing about the complainant's son's disappearance and even plan the procedure to carry out the offence. Thus, mere motive will not be sufficient to prove a crime, but it is an important evidence to be proven. All elements are crucial in convicting an accused. Motive in hearsay evidence. In general, hearsay is inadmissible and evidence of motive cannot be proven by relying on hearsay evidence. The case of Karim Singh and public prosecutor can be referred to where the prosecution relied entirely on circumstantial evidence based on the statement given by the deceased son. However, he did not witness the crime. The court held that it was inadmissible. The other case that can be referred to is public prosecutor and Sarjit Kaur and Perempuan Najar Singh on the grounds for the failure of the prosecution to establish motive due to the testimony being hearsay evidence. Next, for the motive in evidence of custom, to show how a motive operates, the evidence of a custom is also admissible. In Mangal Singh and the King, it is regarding the admissibility of the evidence regarding a custom among Singhs that is to mutilate an unfaithful woman. M. Selwyn CJ states that the act or custom of mutilation was not the motive itself, but it was evidence that may show what the motive was. In the case, the woman had left the accused for another, which has caused shame to him. From this, the prosecution successfully established a motive.
Now, we move on to preparation. Preparation is any act of devising or arranging means necessary. It is a preliminary act or conduct that gives rise to the facilitating a criminal action or production of a crime. The examples of preparation in crime that can be committed, such as purchasing, repairing or removing, procuring, and collecting. In the case of Tianya and another against PP, the court stated that there are 4 stages in every crime. First, an intention to commit the crime. Second, the preparation for commission of the crime. Third, the attempt to commit it. And finally, the actual commission of the crime. Generally, mere intention to commit a crime and making preparation for its commission are not a criminal act and are not punishable under the law. However, although it is not a crime, once an offence is committed, the evidence of preparation is relevant under Section 8 of the Evidence Act 1950. This can be seen in illustration C and D of Section 8, which clearly provides that evidence tending to prove that the accused made preparation to commit a crime is admissible. Referring to the case of Juraimi bin Hussein against PP, the accused was convicted with murder of one Datuk Mazlan. In this case, soon after the deceased was killed, his body was buried in a hole. This implies that the hole has to be dug earlier. It was held that this fact showed the preparation made by the accused by virtue of Section 8, subsection 1. In another case, Bala Murali Mutusami against PP, the appellant was convicted for murder of his wife and sister-in-law by burning. The preparatory act here can be seen where the appellant purchased the petrol is a relevant fact. According to Section 8, any fact that demonstrates or constitutes a motive or preparation for any relevant fact or fact in issue. In this case, there was a relevancy of the request of the appellant to SP9 to buy the petrol.
There are 2 types of conduct, namely previous conduct and subsequent conduct. Previous conduct refers to the conduct before the commission of the facts in issue, where sometimes it may overlap with the preparation, while subsequent conduct refers to the action after the commission of a crime, which may indicate the mens rea of the offender. Next, generally, statement does not constitute conduct unless it is accompanied and explained by the action. When there is no action involved, the statement will only be constituted as conduct when it is a complaint, such as the dying declaration or corroborative evidence. Section 37 of the Evidence Act 1950 deals with the information given by the accused, which leads to the findings of fact. In the case of PP against Aslam bin Hadli, which is a murder case of a Mongolian woman who travelled to Malaysia, the court observed that the conduct of the second accused, which showing at or pointing out at the scene, while stating that itulah tempat perempuan itu diletakkan, as evidence of conduct under Section 8 only, and not a statement lead to the discovery of facts under Section 27 as contained by the prosecution, because such discovery of the scene have been made through the information given by the first accused. Thus, the court held that such a statement made by the second accused as evidence of conduct under Section 8 is inadmissible. Moreover, in Palam bin Tate against PP explained the relationship between Section 8, subsection 2 and Section 9 of the Evidence Act 1950. In this case, the accused looked stunned or shocked upon being approached by the police is clearly admissible under Section 8 since the drug was found in his jeans, which is the facts in issue. Accordingly, the accused must explain himself based on Section 9, but he did not explain himself in his defense at all. Hence, an inference to be drawn from his conduct against other background evidence is that he knew the existence of the drug. In short, evidence of conduct under Section 8, subsection 2 can be further explained to the inference under Section 9 of the evidence.
In conclusion, motive, preparation and conduct are relevant and admissible as evidence in court. However, when the case involves direct proof or evidence, the issue in regard to the motive, preparation and conduct will not become material for the court to be considered. On the other hand, it will be quite opposite for the case involving circumstantial evidence. Therefore, the applicability of Section 8 of the Evidence Act 1950 will depend on circumstances of each case. It is the duty of the court to examine each case, and when the court is on the view that the evidence to the case is not clear, the court can invoke Section 8 of the Evidence Act 1950. I think that's all from our group. Thank you.